Right. Can you hear me now? Can you hear me now? That's good. Yes, I think something happened, but it was because I'm so anxious to making sure that I can hear you, but I must have pressed the wrong systems. But could I again plead that you will uh, 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 you will let me hear your voice. I want people. I want to teach people, not the machine. You know. Um, can I ask any one of you to try? Maybe I had Mr. Sun's microphone on. Can you try your microphone again? Because it seemed that I did hear you. Can you try yours again? I'm not getting any responses at all. Right. Um, I think we're spending too much time on this. Um, right. Can I have another confirmation that you are hearing my voice? You can hear my voice. Could you? Um, that's very good. Okay. Now we were at we were on this slide in front of before you, and that is asking based on Professor Hannum and Linick's analysis. They highlight four features which, according to their theory, are common characteristics of autonomous regions. We were at this point because having heard and look at what was intended in relation to Hong Kong Special Administrative Region in the context of the Joint Declaration and in the context of Article 31 of the PRC Constitution. Hong Kong is and was described as to be a region enjoying high degree of autonomy. And with that background, we want to look at these features, these characteristics, uh, and looking at the provisions of the Basic Law, and come to a view uh, of whether Hong Kong is having these characteristics. And I had asked you to go to the menu, uh, and that is the question or the activity on page 43. On page 43, and as I had hoped that you will have done this, and therefore will be able to participate in the discussion of how of your views on these characteristics and how they are applicable or otherwise in Hong Kong, and if they are, then which are the relevant articles in the Basic Law that reflects these characteristics. We were then looking at chief executive, and here in the box in the menu, the first box is locally chosen chief executive with responsibility for administering local laws. Now, looking at the Basic Law, we had looked at Article 45, Article 48, and others. Now, what do you think? Is that applicable in Hong Kong? Locally chosen chief executive? Does Hong Kong have the legal basis for choosing the local executive, the local chief executive? The end bit of Article 45 says, be appointed by the Central People's Government. So in strict legal terms, the mechanism of the mechanism of election of the chief executive is but a precondition for the CPG to exercise its power of appointment. So it's not a straightforward answer in that the participation or the will of the Hong Kong people as reflected in by the result of the election, one would have thought would be given effect by the Central People's Government in appointing the candidate who won the election. But in strict legal terms, that may not be the case because of the possibility of Central People's Government not appointing the person who won the CE's election. Got it? Second, locally elected legislature making laws on local matters. Two aspects. One is whether there is a locally elected legislature. Second aspect is whether that legislature makes laws on local matters. And is it making laws on all local matters or only on some of these local matters? Can we deal with the first one, whether there is a locally elected legislature? Yes. Generally, it is, isn't it? Except that the choices of candidates, the choice is as reflected by the recent years, by the recent disqualification of some candidates seeking to run the election, may well provide an argument that despite the election, it is not a locally, it's not an election that depends entirely on the wish of local people, because, so the argument goes, although I personally would not find that convincing, but one may argue that there was interference of the election by the government of central government, central authorities, and therefore to make it not a locally, turn the election into a non-local, not entirely local election. And then the making laws on all local matters, the powers and functions. First of all, the legislature, we will, of course, I think, identify that as the Legislative Council established under the Basic Law, and that is Article 66 of the Basic Law. And one is, excuse me, its primary function is to make laws. And the making of laws is only confined to local matters, because foreign, if you like, foreign affairs and defense are beyond the scope of the responsibility of the Hong Kong Special Administrative Region. Thirdly, it is whether the characteristics of independent local judiciary with jurisdiction over local matters. We had looked at this briefly last time, and I think I had pointed to various provisions to say that the judiciary the judges appointed to become part of the judiciary is based on their ability and the competence as a judge, but not their age nor their race or color. Once they are appointed, then under the Basic Law, because they are continuing what they have been doing before 1997, and they are mechanism being put in place to ensure is functioning continue to be independent. And then the last one is independent mechanism for resolving any disputes. The mechanism for resolving any disputes is a broad characteristics, very broad one. It involves the courts, the judiciary is of course the main component of this mechanism, or main part of the characteristics of the autonomous region, and it's been given under the Basic Law the independent power of adjudication, including the final appeal, and that of course is stated in general terms in articles. Article 2, and the Hong Kong SAR exercise a high degree of autonomy, enjoy executive, legislative, and independent judicial power, including that of final adjudication in accordance with the provisions of the law. So that's Article 2. Last one, it could be expanded to either government taking the initiative to resolve disputes, or through the enactment of law, established various tribunals for adjudicating any disputes. Does Hong Kong have all these characteristics, or just some? Does Hong Kong have all these characteristics? The fourth question is about dispute resolution. In considering whether a place is autonomous, one of the characteristics or one of the tests is to see if there is within this place an independent mechanism for resolving any disputes. Any disputes means disputes between persons or disputes between the person and the judicial. Article 85, yep. Article 85 says, what does it say? It's 85. You can all turn to 85, of course, I'm sure. So this is about explicitly describing the judiciary system as independent and immune from legal action. You can see the second bullet point, and here, if we were talking about for Article 158, or rather under 158 creates a mechanism for resolving disputes between parties, between government and persons to person as well. It says as the first characteristics is that in countries, in other countries, normally they might have a court in resolving disputes with the national government. Hong Kong does not have such mechanism. We looked at that briefly last time, and instead the National People's Congress Standing Committee can resolve disputes by interpreting Hong Kong Basic Law. It's something that we find not easy to comprehend, because the system that we are used to, and this system includes the systems of Canada, France, and sometimes these are. Let me start again. In the common law system, courts are independent bodies, and they resolve disputes, either people against people or citizens against citizens, and even citizens against the government. Hong Kong, but what about dispute between Hong Kong SAR and central authorities? Well, there's no such mechanism, and instead, in relation to a matter which concerns the proper interpretation of the Basic Law, it is the NPC Standing Committee which has that authority, and under the Basic Law, a committee on the Basic Law is established, And if there is a requirement to interpret the Basic Law to resolving any disputes, then the Standing Committee is required by law to consult this Basic Law Committee. And at the end of the day, under the system, it is the interpretation by the Standing Committee that counts. And you can see the third bullet here. It says this could include taking away powers from Hong Kong. This is really in the extreme. So if certain view if the central authority exercises its power in, if you like, taking an extreme position, then it would be able to take away powers that Hong Kong enjoys at the moment. Because at the end of the day, under the Chinese system, it is the central authorities which is given all the powers. And of course, these powers can be found set out in the PRC Constitution. Now back to this course, the next slide actually is, this is the place where usually we'll remind students that this high degree of autonomy is a concept which is quite examinable. And so examinable because it involves understanding of some constitutional and legal concepts, and there is plenty of room for a student to express his or her own ideas based on the knowledge of the Basic Law. So when you are looking at questions, exam questions especially, then if there's a question involving what is high degree of autonomy, what is the balance of power, and so on, you should always go back to the fundamental, and that is in the common law system. There are three branches of government, and they are executive, legislative, and the judiciary. The concept of autonomy and therefore autonomous region is something which, in reality, whether it can continue for a long time or just briefly, a short time, and whether as a member of that member of such a what is the word for it? Such a family, if you like. How that sort of arrangement, whether it can be changed at all, right? Because if you want to take the joint declaration to its extreme, and one may argue that there are certain parts of the Basic Law, Hong Kong Basic Law, which is so fundamental that they cannot be changed. Right? And in reality, this concept of autonomy has to be and must be understood in the context of the current relationship between the let me start again. This relationship, I'll put it this way, the extent of autonomy will very much depend on the central people's government's exercise of the powers given to it under the Basic Law, and also the powers given to the Standing Committee of the National People's Congress according to the PRC Constitution. Is by nature, of course, it cannot be a fixed framework. It cannot, because the law, or therefore the legal system, has to cater for changes that may happen over time. And changes are just too normal. It's just part of life. And except that in our case, we are talking about a constitutional relationship established by law. And that is something which persons affected would like to see more continuity than hazard or unsystematic changes. For in the context of the relationship between the central authorities and SAR, we had tried to first of all we look back and from 1997 up to this moment, we can see fairly three distinct era or period. First is the period of 1997 to 2003. That is during the time when the central authorities' policy over Hong Kong is rather generous, and the unlawful assembly offense can be brought down to something less serious. And as you can see from this slide, 1997, there were many people who are on the street marching and at the same time expressing their frustration and also their wishes. I don't know where the picture was taken. Okay. In our case, back to the current era, post 2014, and there you can see this is a book produced by some non-profit making bodies, and it's meant to secure. This is the period, the maximum autonomy. This is at the beginning, or the first 6 years, when China was very careful not to interfere. And you remember the common expression of river water do not interfere with water in the well. Then come year 2000, the period from 2003 to 2014, the more direct involvement by China after the 1st of July protest rally. 2003 is the year when there was flu. There was this SARS epidemic. Hong Kong was undergoing a few months of a very difficult time, but it got back on her feet quite soon. Only about 3 months of pandemic, and so following that, Hong Kong has entered into a period of China exercising more direct involvement. in various aspects. I don't want to pinpoint each one or a particular one. But then, in terms of the evolution of the relationship, having touched on the two periods before 2014, you have a very distinctive period of post 2014. 2014 was the year when the Guowu when the Chinese government issued a white paper on the one country, two systems. This white paper, the most important parts of it are reproduced in your manual from page 44 and up to page 45. Very important two boxes of information, and the first one on, if you turn to we can turn to page 47 for the let me see, extract. Well, extract 1 is on pardon, pages 44 and 45 is extract 1, but because of time, I think we better go to extract 2 right away, page 47. And there the white paper was trying to put right a lot of what they call misconceptions or misunderstanding of one country, two systems, and how Hong Kong is an inseparable part of a local administrative region. And then it kept on reminding people that we are talking about two systems. When we are talking about two systems, do not forget that these are two systems under one country. Have you all got the menu? I just want to double check if you have the menu with you. Do you have the menu with you? That's good. What I would like you to do is, if you have not already done, because the white paper is very important. The white paper, important in the sense that it is the official, it shows the official understanding of the Hong Kong Basic Law and how it had explained herself in writing what the proper constitutional concept and relationship there is between Hong Kong, SAR, and the Central People's Government. Right. If you look at learning activity number 3, first of all, it is asking you to read the extract, and secondly, create 2 separate lists, and then fill in the list. About 10, give yourself, the list is this. The first one is to contain statements concerning what the Central People's Government believes are the essential elements of one country. Secondly, it is about what are the essential elements of this second system. And all right, you see, these are the questions asked, and what do you think is the most important excuse me, element, right, in the one country, two systems principle? What is the most important element? Yes, one country. You? Who type in one country? 301. I was trying. Let's try. Okay. Any response? Is it one country or is it two systems? Well, if you look at the extract, page 48, you look at page 48, and one country, two systems, it says one country, this is the second paragraph on that page. One country, two systems is a holistic concept. The one country means that within PRC, Hong Kong SAR is an inseparable part and a local administrative region directly under the China's Central People's Government. Right. That brings the concept of the very important relationship of delegation. The nature of the relationship is one of a delegator and delegatee. And then it goes on to say, as a unitary state, China's central government has comprehensive jurisdiction over all local administrative regions, including Hong Kong SAR. When in 2014, when this white paper was published, there were some people taking exception to the reference, the expression of CPG exercising comprehensive jurisdiction over Hong Kong. This comprehensive reference comprehensive, was criticized as having undermined the concept of two systems under the one country, two systems. But as I've been saying, that but then when one goes to the PRC Constitution, then you will realize that there is a legal basis for this position, i.e., exercising comprehensive jurisdiction. The point is, for those who did not think that was right, will have to review very carefully the definition of two systems in this one country, two systems policy, and to what extent, or if at all, it means independence, or a relationship of no control. I don't want to repeat or read again what is here extracted for you, but when you read it, or after you have read it a couple of times, you will realize this relationship surely does not mean Hong Kong standing on its own, doing whatever she likes, and it cannot be cannot regard herself as a body that one day will become independent of PRC. That is simply not the case, and the emphasis therefore had all along been having Hong Kong or CPG giving Hong Kong whatever they think should be given as far as powers are concerned. So, and because of this, in terms of hierarchy in this national policy, the hierarchy of one country must be read, has to be understood above that of two systems. But two systems come under or after one country. Okay. So I'll leave you to read again the white paper as having been extracted in your menu. The next slide is to ask you to turn your thinking cap on, and with the question of further changes in the future. Now, this slide was prepared. When this slide was prepared, it was before the National Security Law was made by the Standing Committee, and even then, we see that China actually has many powers under Hong Kong Basic Law. It certainly has a lot of powers, and this phenomenon reflects the nature of China, being a unitary state, and the way that China sees the relationship between mainland and the Hong Kong SAR the relationship is one of comprised of two very important elements. One is Hong Kong is an alienable part of Hong Kong, part of China. It's part of China. And secondly, whatever powers that Hong Kong is given, that means executive power, legislative power, and judiciary power, are all given by way of delegation. As I said last time, when somebody delegates a power to another person, that delegator can always rescind or take back the delegation. Back on this slide, it was we used the heading further changes in future. Of course, we start by saying that, and I just explained that China does have many powers under the Hong Kong Basic Law that it has not used, rarely used. And in relation to legislative powers, under Article 17.3, Legislative Council make law, and these law usually passed on a Wednesday, sometimes maybe Thursday. That law should then be given to the President of Legco to sign, and then will be taken to Beijing. For its reporting. And under Article 17.3, apart from the reporting, then it follows that there will be for the record, taking the ordinance, the bill passed by Legco, and will be treated as a local law, as a Hong Kong local law, and the central authorities, as represented by the Standing Committee of the National People's Congress, under that, in that capacity, the committee, i.e., the standing committee, has the power to return the law to Hong Kong. And once it's returned, then it will start having no effect. It will start having no effect. Now, this is a very important power, and of course, and similar power did exist pre-97. Now, in the case of Hong Kong post-97, so far, no law passed by Letchole have been returned under Article 17. It has, of course, raised some of the laws raised concern by central authorities. Now, if that's the case, if central authorities cannot tolerate such a law being made, and if they did not want to raise it as such a high international, raise it as a international issue, then the standing committee usually will not exercise its power, even if they have certain views on those laws. But the scope of power, though, we have to read the article very carefully, is not all-embracing. It only covers laws that concern the matters that are under the responsibility of the central authorities in accordance with the Basic Law, or it concerns matters that relate to the relationship between the central authorities and the Hong Kong SAR. So there are certain laws which they fall outside this power of returning, the law, and these may be ordinances which only concern private organizations, or some private organizations, either religious ones, or a school, or a hospital. Article 18.2 and 4 actually specify that no national law can apply to Hong Kong SAR unless it goes through certain procedures. And these procedures are, first and foremost, is to have these laws, national law, listed in Schedule 3 of the Annex 3 of the Basic Law. And not every law can be so annexed. It has to be laws. It cannot place. It can only place laws that could relate to defense and foreign affairs. Defense and foreign affairs, not everything. And once a national law is listed in the Annex 3, it doesn't mean that it will automatically become laws of the Hong Kong SAR. It will still have to go through one or the other, one of two processes. One is for the Chief Executive to make a promulgation, i.e. a formal declaration, that that law has become law, that Chinese national law has applicable to Hong Kong SAR. This is by way of promulgation. The other is by way of enactment into local legislation. Just like more in recent 2 years, 2-3 years, the law that became or that is applicable in Hong Kong is by way of promulgation, done by way of promulgation, is the PRC law on the national security, in Hong Kong. That one, there's no local discussion in the Legislative Council before it was promulgated as having legal effect in Hong Kong. The other one, which took a bit longer, was the anthem law, the law that protects the integrity of the song of the national anthem, and also provided clearly on what kind of occasion that the national anthem has to be played. That is by way of local enactment. Local enactment generally is seen to involve possibly longer time, more discussions, sometimes more conflict. Promulgation is more direct, but simply promulgation sometimes will leave or may leave points of law unsettled or unclear. You will find that the national security law actually had made some very special provisions in it for making sure that despite the fact that it is a PRC law, it can, or PRC made law, for taking effect in Hong Kong, it has used expressions that this company used in Hong Kong to avoid misunderstanding. So this is on the slide of future changes in raising a question. One may argue that these changes, PRC or Central People's Government, have been changing. There have been changes in their attitude towards leaving Hong Kong, or rather having Hong Kong people ruling Hong Kong, and not to have any influence on that by the Standing Committee, by the central authorities. I gave a link here. I don't know whether. Oh, yeah, this is the link, and let me share screen with you. Oh, let me do a share screening with you. Oh. Okay. I think it's this one. Maybe we can share. Can you see this? Can you see this? No sound. Let me see. Okay. Now I won't venture to do anything because I just fear that I might end up end up losing you altogether. So there's the link, and I would encourage you to spend a moment to hear the what Mr. Gitting said. All right. So what he said at the on that occasion is actually very much what he had written in his book, and the conclusion is really for us to watch the space, if you like, or and be reminded that the power, because of the power that PRC enjoys as the sovereign power in a unitary state, and also standing committee under the Constitution, PRC Constitution, and the Basic Law enjoys the power of interpretation. Changes, if it was intended to make any changes, and of course that changes in the context of what we had looked at previously, where it seemed that the PRC government can, and not only can, but sometimes they see it as a need to adapt the policy, its policy to the prevailing circumstance, right? And just like when you look at the history that or official statements on what had led to the making of the national security law in Hong Kong, you will see that it was mainly because of two factors. One is 23 years down the road, after 97, Hong Kong still hasn't made any laws on national security in accordance with Article 23 of the Basic Law. And secondly, it was because of the social disturbances that happened, that occurred since June 2019, which was considered as causing a threat to national security, both on the mainland and particularly in Hong Kong, with the alleged participation of foreign powers. And that was the background to it, and you could see, and it was actually back in 2013 that Mr. Gittings actually saw this, right? So this is, and I put on Article 22 here, Article 22 of the Hong Kong Basic Law, and which the first paragraph provides that no department of CPG and no province and so on may interfere in the affairs which Hong Kong SAR administers in accordance with the Basic Law. In that context, and I remember I mentioned that last time, under the national security law, though, there is the body which it is called the Office for Safeguarding National Security of the CPG in Hong Kong SAR. It has established itself here, and one view was that contravened Article 22, but on the other hand, that was considered, of course, by the central authorities that it didn't. So that was something you should be aware of. And the views, the official views taken was, if you can, I'm afraid the resolution is not very good here, But you will see that the official statement given by the Secretary of Justice was she didn't think that it sort of fall foul of Article 22, but the Hong Kong Bar Association took a different view. All right. So on this, I think I will conclude the presentation on Chapter 4, which is a review over the powers that are given to the Hong Kong administrative region for it to enjoy a high degree of autonomy under one country, two systems, how that is being done, and what in practice, what actually it is like, and then for you to make your own assessment as to whether a high degree of autonomy means, or form your own view on the actual meaning of high degree of autonomy. Right. Let's take a break now, 15 minutes, and let's come back at 2:40. 8:40. Are we all right? Thank you. Currency, which is separate from the renminbi. Hong Kong has a custom area, custom territory, independent of the mainland's custom authorities. Cultural relationship, economic relationship with other parts of the world, as long as we act under the name of China, Hong Kong, China. And also the fact that we are given the authority to issue passports and have our own control of entry and exit of foreign nationals. But despite all that, of course, I have been saying that China still retains, well, not retains, but the ultimate power rests with China as the unitary state. So when it comes to 2014 in the Basic Law, in the White Book, in the White Paper that was issued, China as the state was emphasizing having a comprehensive jurisdiction. So it's not clear if the Basic Law allows China to directly control how Hong Kong SAR exercises some of its powers. Now, for example, I put in here locking down. The lockdown during pandemic. We are now in the pandemic for nearly a year now, and you can see the way the fight against the pandemic is being undertaken, and at various points during the last year or so, you see the attitude adopted by the mainland authorities in treating Hong Kong SAR as a place which is separate and distinct from that on the mainland. Lockdown, for example, there's no general policy. Lockdown is subject to Hong Kong law, Hong Kong government decisions, right? And it is quite different from that on the mainland in relation to other places. And but one does say though, conceptually, China always has control over Hong Kong, and because back to the point I made, it is the central people's government that who appointed the chief executive, and despite the fact that CE is head of Hong Kong government, it is provided quite clearly in Article 43(2) that CE is accountable to CPG in addition to Hong Kong SAR. So this dual accountability is something which is so unique, and at times, if the interest of PRC and that of Hong Kong SAR are in conflict, then this dual accountability would be put to a very strenuous test. How is CE able to discharge this duty of being accountable to CPG and Hong Kong SAR if the two are having conflict in their respective interest? The pandemic, of course, we don't know enough, but just in theory, the way that the pandemic is being treated, or rather tackled, may due to different concerns. Of course, as I said, we don't know enough yet, but when it comes to time that we could sort of look back and review, more things could come out of it. If you look at some of the articles, like Article 48(8), 48(8) gives the or makes it clear that the central authorities, the CPG, can actually give directions to the to CE for CE to implement. The wording of 48(8) is this: to implement the directives issued by the CPG in respect of the relevant matters provided for in this law, i.e. the Basic Law. So those who advocate direct control because of for example, safeguarding the national interest or national security of Hong Kong, it doesn't really need to, in strict legal terms, you don't need any local laws to be made, or even national law, as long as the CPG gives directives to the CE to do this and to do that. So the mechanism is there, which does enable CPG to exercise control, either directly or through the CE. Look at this unwritten obligation on the CE to report annually, at least once a year, to the central government. We just heard news that Carrie Lam, the CE, was supposed to perform her reporting or discharge her reporting obligation last week, but now delayed for whatever reason. So and this you may say that, well, this is really symbolic. Yes, in a way, it is symbolic, because if any formal reporting needs to be done, that could be done without physical meeting face to face. She could do it on via electronic means, but the symbolic, this is a reflection of the proper relationship between Hong Kong and central government. It is for her, the CE, to make a report, because she is accountable to central government under the Basic Law. And at this sort of atmosphere, at this sort of under such arrangement, of course, the state leaders and give guidance to CE on major issues. One of which you may think, through the publication of the white paper, is another means of exercising control by telling the CE and, of course, the world at large what is the proper relationship between Hong Kong and the central government under the Basic Law. The making of law is another special feature under this one country, two systems. We definitely have two systems of laws, and I mentioned to you last time about the lawmaking mechanism in mainland China, which is headed by the supreme organ of power, which is the NPC, and then with this executive arm, the standing committee of the NPC. They make laws, all areas, and except that for the basic laws, only the National People's Congress has the power to make. And then below that, you have the States Council, and then the various provinces and government departments that can make law, under that hierarchy. Hong Kong's power to make law, very broad indeed, though. And this is similar, in a way similar to other autonomous regions in China. I mentioned to you, though, the relationship or the power that's given to Standing Committee of NPC to return any laws which, in its view, contravene the Basic Law. But that is a limited power because it only applies to laws under which it applies to laws which regulate matters that are under the responsibility of the central authorities, or it concerns the relationship between central authorities and Hong Kong SAR. Restrictions that apply to Hong Kong LegCo are under 11.2, laws made cannot contravene the Basic Law. Under 71, such laws has to be made in accordance with legal procedure and the Basic Law. Legal procedures and the Basic Law. So these are very wide lawmaking powers. Indeed, if you look at Article 23 of the Basic Law, it also empowers Hong Kong SAR to make laws on national security matters, on those 4 areas which are specified, and those areas are the treason, cessation, sedition, and subversion. Right? At the moment, except for secession, the rest actually can be found in the existing law, or pre-1970 law, which is now Hong Kong SAR law, which is the Crimes Ordinance. And there you find the offense of treason, sedition, and also under the Official Secrets Ordinance, there's the which protects or act which punishes theft of state secrets. So that's the lawmaking power. I mentioned to you about national security law. That's the recent event which the recent event of introducing the Chinese PRC law on safeguarding national interests in Hong Kong, which although even it is common in other countries for such laws to be made, that is something not popular in Hong Kong. And Article 23 is also itself seem to be an exception to the general rule, the general phenomenon that national security laws are made by the core, by the central authority. Right. So if one wanted to compare Hong Kong's lawmaking power with those those not autonomous areas, like autonomous areas for the Mongols in Tibet or in Xinjiang. They are quite different. They are quite different from that in Hong Kong. Just reviewing the relevant provisions again. Under Article 17.3, the Standing Committee has power to return Hong Kong laws in only two areas. One, affairs which are responsibilities of the central authorities. Second, regarding relationship between Hong Kong and central authorities. This power, therefore, does not apply to laws which is not on Hong Kong internal matters. And the law, when it only will become invalid when the law is returned. No earlier, not later, but at the moment of return. Lastly, we should note that China so far has not used its power to return law. The flip side of the coin is, can Chinese national law, other basic law, or national law apply in Hong Kong SAR? The answer is yes, but we have to learn the mechanism. It has to go through certain mechanism, otherwise it would make no sense of having SAR. The mechanism is this: the Standing Committee will start the process. It will consider which of the Chinese national laws should apply, and Articles 18.2 and 3 imposes restrictions. These restrictions, some are restrictions on form, other is on the requirement that they have to consult the Basic Law Consultative Basic Law Committee. But even if a piece of national law has been included in Annex 3, it does not mean automatically that piece of mainland national law becomes part of Hong Kong law. It has to go through the procedure of the provided in the Basic Law and in the relevant Hong Kong Ordinance. In short, only Hong Kong can finish this process of applying Chinese law in normal circumstance. Of course, the not normal circumstance would be the national security law. So, what are the restrictions? National laws only apply if they have been listed. They are listed in Annex 3 of the Basic Law by the Standing Committee. Secondly, either it's promulgated by CE or enacted by Legislative Council. Promulgation will be straightforward, will be paper exercise. Enactment, that goes through the full rigmarole of the lawmaking procedure, and sometimes very theatrical, and also taking much longer time. Only laws about defense, foreign affairs, and other matters outside Hong Kong autonomy. These are really the kind of law that can be included in Annex 3, not only at the wish of the Standing Committee, but this has to be applied properly. Recent example that led to some controversy is the establishment of the West Kowloon Terminal, where for the high-speed train, where the mainland port area is physically located at the building at the station, which is on Hong Kong land, Hong Kong soil. How this national law listing of national law in Annex 3 has to be done. The next few slides take you through them fairly quickly. For example, the national law in Annex 3, this is not one example we want to highlight is the example of the Chinese nationality law. That law was given an interpretation before 1997. That was to deal with the British. What's the word for it? I can't remember. This is to deal with the the British nationality scheme, under which people who are qualified by way of wealth or by way of profession can apply to obtain to become a British citizen and become and be issued with the UK passport. That policy came about before 1997, and it was one of the things that the Chinese government did to respond was to make an interpretation to the Chinese nationality law, and it was provided that these UK passports issued under this program, under the scheme, can only be treated as travel documents. They are not evidence of nationality. So when it comes to practical significance, you will see that people, if there are people who were born in Hong Kong, entitled to BNO status, British National Overseas status, when the matter which concerns them very often is whether they can use the British passport to travel back to the mainland. Now, first of all, if they want to use that British passport as a British citizen, then they will have to get a visa. And whereas if they use the normal home return permit, then that's much easier. And as long as they are somebody who is a citizen of Hong Kong, can apply for the re-entry permits or home return permit. And because of this, you will see that there was an interpretation of the nationality law, but before 1997. After 1997, whatever law need to apply to Hong Kong, it has to go through the Annex 3 procedure, and that is a long procedure. And putting this into the context of one country, two systems, in the context of how much mainland China controls Hong Kong, that becomes a very important point. Yeah, and but this is one which concerns a lot of Hong Kong people, and I just recently heard that there's a rumor that because of the UK government's announcement of policy to facilitate holders of British national overseas passport to settle in UK, Chinese government is maybe doing something at the sort of diplomatic level to counter that policy. There are various means for the Chinese government to act, and of course this is now has now become a foreign affairs issue, and it's only Central People's Government will have the necessary legal authority to deal with that issue. The next slide I want to show you is within this very unique relationship, one country, two system, or relationship of SAR and Central People's Government, is Hong Kong's authority to issue a passport. Passport, as I said earlier, signifies sovereignty, and here Hong Kong has this authority. Now the colors changed. It should be, it should be something bluish. Right? So this is, if you go to the Hong Kong government website, you will see how that is being described. And this tells you the interpretation that the Senate Committee put. And I don't know whether this might be subject to future change. So back still in Annex 3, and still saying that the mechanism is such that China, or mainland China, has the ultimate power over Hong Kong SAR. But there are limitations. These are limitations set down in the basic law passed by National People's Congress. But other laws, you will see that it is only the SAR that can finish the process of applying the Chinese laws, because promulgation, CE is the only person who can do promulgation. Enactment by LegCo, it is only if government introduces a bill to LegCo for passage. Otherwise, LegCo can't even exercise that power to enact law. Second point, laws normally promulgated by CE, if can use same wording as in China. Well, this is where with the two methods, which method does CE use? CE would normally do promulgation if, for technical reason, the same wording can be used as in China. However, it's not always the case. Like the National Anthem law, when you look at Section 15 of the National Anthem law, that part of law involves some form of punishment that does not exist in the Hong Kong system. Then that has to be changed in order for it to make any sense in Hong Kong. So there will be this change of wording of a law that has been included into Annex 3. And so far, only the national flag law has been enacted, and I must add, it's also the National Anthem law, which was, I think it's July, and it was formally enacted. There are other laws, such as law on foreign central bank, that having included into the Annex 3 has not been promulgated, nor has it been applied, and therefore it hasn't been applied in Hong Kong, but it is there. It is there. At times of emergency, under Article 18.4, CPG can forget about all this mechanism, all these requirements that of works, things that it has to do in order to apply the national law in Hong Kong SAR. If it is at a time of state emergency or state of war. Obviously, you are talking about very unique and also unique and also emergency, and even like human rights, where under such circumstance there could be some derogation of human rights too. The wording state of war, I think we understand it. We at least conceptually, you will understand what is the state of war. Not concerning ourselves about technicalities though. But state of emergency is a less precise concept. What is state of emergency? How urgent, how critical something is before it can be called emergency? It's difficult to tell. Huh? And however, if such a situation happen, who decide? Well, Article 18.4 says. 18.4 says for declaration of war, it is the NPC, and as far as the state of emergency, it is for the standing committee to make that decision whether it is in a state of emergency. And once that decision is made, then the CPG may issue order applying relevant national law in the region. So if a state of emergency occurs or is happening, there is no need to list them in Annex 3 or have that law promulgated or enacted in Hong Kong. Further, when we look at Article 6 of the law on garrison, the Hong Kong SAR gives Chinese Army the power to enforce those laws in Hong Kong. A very important linkage. State of emergency, I said to you, there's no legal definition. There's also another local legislation, which is Section 2.1 of the Emergency Regulations Ordinance. It provides as follows. On any occasion which the Chief Executive in Council may consider to be an occasion of emergency or public danger, he may make any regulations whatsoever, which he may consider desirable in the public interest. The note of Hong Kong BL only listed 5. Which note are you referring to, Leung Kam Soon? Which note did you refer to? I think as of today, let me see. Let me just go to. because some of these do not get published, I have to do a last check. On mine, there is a footnote which adds quite a few, but then this version is fairly dated, so I can't be confident. I'm not confident that this is the right figure. I'll get back to you later on that. I often, whenever this question arises, I have to go back to DOJ's website because they are supposed to provide us with the up-to-date last count. Right. I pull up this because under the Emergency Regulations Ordinance, Section 2.1, the Chief Executive can make regulations, whatever regulations he or she thinks which is desirable and in the public interest. This is as long as the CE thinks that it's desirable in the public interest, then if she thinks that Hong Kong is at the occasion of public danger or emergency. Now, the anti-mask law was made in October last year, and it was made on the Chief Executive's assessment that Hong Kong was at an occasion of public danger as opposed to emergency. Public danger itself is not, there's no legal definition, so it is a matter for the Chief Executive to form her own view. Of course, that view is could be reviewed by the court under judicial review in judicial review proceedings. Section 2.1. So this is different from what I referred you to earlier, Article 18. Article 18, fourth paragraph. There it was referring to a state of war and also state of emergency. And if there was state of emergency, then the CPG can disregard the requirement of listing the law in the Annex 3, but go direct to declaring that certain law is already become is already applicable in Hong Kong. The anti-mask law case has been heard by the Court of Final Appeal, so the judgment on the constitutionality should come out anytime next week, I hope. If not, anytime before Christmas. Another recent example which has drawn a lot of attention and discussion on the application of national laws in part of Hong Kong. Now this arises because the express rail link will travel into Hong Kong SAR from the mainland and then stop at Kowloon, West Kowloon, which is the terminal, and passengers and luggages will be checked. For passengers, you know the requirement of clearing immigration. Normal arrangement without this is for a traveler to be checked at Hong Kong side before he or she steps onto the train, and this is outbound passenger from our standpoint. And when this outbound passenger gets to say Guangzhou, then he will have to go through immigration, go through custom, same checking, and so in order to facilitate movement of the people, the two governments, the Shenzhen government and the Hong Kong government, did enter into dialogue and agree to arrange or to build a rail station in Hong Kong, to be precise, in West Kowloon. And because of that, you see that a passenger, they will have to clear custom twice on the same day at the same building, but different spots, different location though. And whether that contributed to basic law or not was a subject of litigation. This is just a picture, and you will see how the movement of people is required. And I don't propose to go through this with you, but it is interesting design. The laws that apply, national laws because although the mainland port area, I'll show you the picture. Although the mainland port area, we need that picture. Well, maybe this one is good enough. So this is the 4 levels within the same building. Officers wearing blue are the mainland officials. They will be applying Chinese law, national law, here, on Hong Kong's soil, if you like. That gives rise to the concern that because these are law enforcement agencies of the mainland, and they can only enforce mainland law, so are we saying that mainland China can have its national law applicable within the boundaries of these agencies, within the boundary of boundaries for demarcating this as an area for mainland China? But such is an act of achieving the same through design is not legal, because no matter what you call it, it still involves substantially mainland law to have taking effect on Hong Kong land, on the land of Hong Kong. Right? That will be against fundamental principle that laws application can only apply within your jurisdiction. So that was the problem, that was the issue, there were discussions, and eventually the case was decided by court. But before then, the Standing Committee made a decision. The decision in gist is that the cooperation arrangement between the 2 governments, one of which was Hong Kong SAR, is consistent with the principle of 1 country, 2 systems, and is consistent with the Constitution and the basic law of the Hong Kong SAR. And the Court of Final Appeal held in December 2018 that on the basis of the National People's Congress Standing Committee decision, the co-location ordinance was consistent with the basic law. So that was the finding of the judge, first instance judge, Mr. Justice Chow, the same judge that recently found the police had failed to discharge their duty by allowing some of the police not wearing their some identification features. Okay, so the question was raised, and the court decided that in 2018 December that on the basis of the Standing Committee's decision, the co-location ordinance was consistent with the basic law. What about judicial power under 1 country, 2 systems? Judges aren't they given an independent power to adjudicate without interference? So, on the face of it, such arrangement will or may undermine the independence of the judiciary. We ask ourselves the first question: how is judicial power granted to Hong Kong different from executive and legislative power granted to Hong Kong? How are they different? How is it different? Do we know? Are they the same? How are they different? Where can we find the granting of power to judicial power to the judiciary? Do we find anything useful? Article 2 looks again. MPC authorizes Hong Kong SAR to exercise a high degree of autonomy and enjoy executive, legislative, and independent judicial power, including that of final adjudication, in accordance with the provisions of this law. So what does it tell us? Judicial power is important, is essential, more because it is independent. It's independent from all sources. So that is MPC I know Article 2, right? Okay. Different from executive and the legislature. Here I'm talking about the judges and how are they different? Well, the CE is accountable to central authority, right? But LegCo, of course, is not. It's not accountable to anyone. And even the MPC Standing Committee only has limited power to stop Hong Kong laws, to stop Hong Kong and start making laws in Hong Kong. So the only power is the power to return, and it's limited, as we had looked at the slides earlier. Only of the two areas that the Standing Committee can actually do something. Otherwise, they are just lack of power. Seems like. And two methods, one of which is the promulgation. Okay, so laws of garrison, it gives Chinese the army power to enforce laws. And then less directly, CBG can directly apply any national law, but only when there is emergency. Only when there is emergency. Okay, got it? Judicial power, as I said, it is different from executive and the legislature. The executive is accountable to central government. The Standing Committee has limited power to stop Hong Kong laws and start making laws in Hong Kong. Independent judicial power, the Chinese courts have no power over Hong Kong courts. So quite self-explanatory. I don't think you need any explanation. But one thing is, yes, when adopting the way this jelly, um, so in terms of judicial power, you will see that the Chinese courts have no power over Hong Kong courts. Chinese courts have no power because they are, they come under different legal system, so they can't have a relationship of more senior and less or more or junior, such as, you know. So there's no such relationship. Chinese courts do not oversee Hong Kong courts. But having said that, please don't forget there is increasing number of cases that concern mostly commerce or trade of people from Hong Kong entering the contract from people on the mainland. And when there is a dispute, they then would have to rely on both the courts of Hong Kong and those on the mainland to either start the action or before trial asking for restraining measures, restraining orders to keep the assets of a defendant intact. Otherwise, they will dissipate, take them away somewhere else. My next slide is to say that it's different from executive and the legislature. How is it different? Well, the executive and the principal officials, they all have nationality requirements, whereas for the legislature, only or at least 80% must be Chinese without right of vote anywhere else. The judiciary, actually only 2 judges must be Chinese. These 2 judges are the Chief Justice, i.e. the head man. The head at the moment is Mr. Justice Ma, Geoffrey Ma, and the Chief Judge of High Court is Mr. Justice Poon. Mr. Justice Poon. The Chief Justice, Mr. Justice Ma, is retiring next year, early part of next year. His successor has been named already. Do you know who his successor is? Who is the next CJ? Do you know? Do you follow the news? Who is going to be the next successor? I mean the successor, rather, the next CJ. Do you know? Not sure what they are? I lost the dialog box. I don't know where. Let me check. Uh-oh. Sorry. Oh, it's there. My goodness, where are we? Suddenly moved something else. Oh no. So, where's our slide? I've lost it. I'm not going to be too ambitious. I'll stay where we are. Okay. The two judges. So the next Chief Justice is Mr. Justice Andrew Zhao. Mr. Justice Andrew Zhao. 張舉能，張舉能啊。Where's your box? Where? Oh, it's here. I found it now. Foreign judges, under Article 92, judges are chosen on the basis of their judicial and professional qualities and may be recruited from other common law jurisdictions. Right? So it's quite clearly this is to maintain the pre-97 system as far as possible. So judges who are not of Chinese nationality are not required to leave but can continue performing service as a judge. And under the Court of Final Appeal Ordinance, and also consistent with Article 82 of the Basic Law, there are judges from overseas common law jurisdiction to sit on the common law, to sit on the judges panel in CFA, the Court of Final Appeal. The presence of foreign judges in the Hong Kong judiciary had drawn some criticism and discussion, especially when the high-profile sensitive cases are decided by judges who are non-Chinese. But these are more perceptions, and looking at various provisions in the Basic Law, I think it is clear, and nobody really disagrees, is the law preserves the common law legal system in Hong Kong. These are some of the articles: 8, 1882, 86, 92. They create a system that not only that the common law continues in Hong Kong, but also, as referred to just earlier, the Court of Final Appeal can invite judges or senior judges from an overseas jurisdiction to hear cases. China has a different legal system, of course, and therefore, we don't have judges hearing cases from Hong Kong. But involving Hong Kong, though, those are cases that has become a regular occurrence. We look at the power of final adjudication. This is a rare arrangement for a place which does not enjoy sovereignty or part of sovereignty if it's separable. The emphasis, though, in the Basic Law is rather the arrangement to have an independent tribunal to exercise the power of final adjudication, which means the power to decide court cases generally. And they have limited power. That court has limited power pursuant to Article 82. And in other autonomous areas around the world, the power of final adjudication normally rests with the national court. Occurrences that had thrown doubt to this independence of the judiciary was the involvement of organs such as the Standing Committee of the NPC on interpretation. And also, and that of course, from the point of view of some, upset the constitutional arrangement in the Basic Law. The constitutional arrangement, I think, at the time when the last edition of the Constitution was amended, was to obviously find the right candidate to work with the firm, but also be able to communicate or travel to the mainland to hold meetings face to face using 普通话. The final adjudication, does the courts in Hong Kong have that power? And the answer is fairly straightforward. It must be a yes. However, because of Article 158(1), some doubt had been established that the Chief Judge, when sitting as the top judge at the court, the Standing Committee can make a interpretation which is different from the finding of the court. That could be quite embarrassing, right? Isn't it? So in a normal run of cases, under Article 158(3), the interpretation has become mandatory when the proper interpretation of a certain provision in the Basic Law will be determinative of the result of the case. Now, if that's the case, then the Court of Final Appeal must refer the case to Standing Committee for interpretation, and once the interpretation is done for that case, the Court of Final Appeal will be bound by that interpretation. However, if it is a situation where interpretation came later than the judgment, and if the person affected by that judgment had done something which is not reversible, irrevocable, then the court, then the interpretation of the Standing Committee must prevail. So on that basis, can one really say, in absolute terms, that the Court of Final Appeal does not have power to give a final interpretation of the Basic Law? What will be the answer? Does the Court of Final Appeal have the power to finally decide a case? Yeah, no. However, we have to look at 158(3) more closely, and that, interestingly, similar to Article 17, which regulate the power of the Standing Committee in returning laws to Hong Kong, you will find the same qualification appears, i.e., the case must involve matters which are under the responsibility of the central government, of the central authorities, according to the Basic Law, or the matter concerned the relationship between the Standing Committee and the relationship between the Standing Committee and the Hong Kong SAR. So it seems that not every kind of case has to end up in the Standing Committee being invited to interpret the law, only those within those two areas. So that so the answer about whether CFA has a final interpretation is not an absolute answer. It really depends what the nature of the case is. Right, that in a way that came to the end of my slides on one country, two systems, on the relationship between Hong Kong SAR and Standing Committee. Any questions? No question. Good. I want to move on quickly to system of government and system of government under the Basic Law. As I had said, for the purpose of our course, we will focus on the relation on the two arms of government here, the executive and the legislature. The judiciary will be mentioned only in this context. If the provision involved touches upon the judiciary, then we'll go to look at that as well. We will be concentrating on Articles 43 to 79 of the Hong Kong Basic Law, and it is Chapter 5. It is Chapter 5 of Mr. Gittins' book. The arrangement of the Basic Law is such that the system of government, you can deduce from the provisions on what kind of system the Standing Committee was establishing. First of all, Chapter 4 got 40% of Hong Kong Basic Law. What is in fact of Chapter 4? What is in Chapter 4? Do we know? What's Chapter 4's heading? Political structure, right? And this is more internal, local in a sense. This is so political structure. Section 1 is headed the Chief Executive, and it comprises Articles 43 to 58. Then Executive Authority with the CE as head, 59 to 65. Legislature, 66, that established the legislature, called Legislative Council, and then followed by provisions, relevant provisions that spell out the authorities of and indeed the function of the executive authority, Articles 59 to 65. The legislature, 66 is the one that created the legislature. Then it goes on to defining its powers and also the qualification of the president, and then some of the provisions therein actually deals with the relationship between the legislature and the executive authorities, and you will need to focus on those as well in understanding the political structure of Hong Kong. Judiciary, Article 80 to 96, and then district organizations and also public servants. And you see on this slide that our focus is on 1, 3, and 4, i.e. this is going to be on the CE, on the legislature, and the judiciary. Right, these are the previous abbreviations which you should be aware of, familiar with. And CE means Chief Executive. LegCo, not LEGO, is Legislative Council. The basic law doesn't say, oh, this is a system of separation of power, or oh, this is a system of executive-led, or this is a system of legislature act. It doesn't say so. It only tells you what each part of this political structure does and what how and what are the qualifications of these members. And so whatever adjective or description you use is not legal. It's not legal. Right? And you must decide which one you think is correct. Now, when we say that you must decide which one is correct, as a student of the basic law, you should be able to explain why you think your description is correct, or why you think the other descriptions are not correct. When we say executive-led, what do people mean, and whether it is an accurate description? Well, this is China's preferred name for system under the Hong Kong Basic Law. But of course, this is not absolute. Some scholars actually have described the system as the CE-led, Chief Executive-led government, because those who advocate that says that because CE is head of Hong Kong, and looking at its powers, that power actually prevails. The power that belongs to CE himself or herself prevails over powers of the legislature and sometimes the judiciary as well. So, with this being the situation, if you describe it as executive-led or a CE-led, it signifies one's observation that CE is more powerful than both the legislature and the courts. You are asked why here, why you think it's justified to describe it as CE-led, executive-led. Do you really have a CE who is that powerful? Well, look at the articles 48, 49, 50, 74. You will see that 48, which set out the powers and functions, and you will see that every one of which is the CE controlling either some business described generally, or controlling like public officers or civil servants or other public servants, putting them under her control and subjecting them to directives made by the CE. Just looking at them very quickly, I think you will have this, you remember this better. You see, when you look at 48.6, this is in relation to judges. This is the CE who appoints the judges, also the CE who removes the judges at all levels. At all levels. And it is for the CE to appoint or remove holders of public office in accordance with legal procedure. Okay, so the CE is really very, very powerful, and these are, of course, evidence of executive-led. The logic is because it is taking into account that the CE is head of Hong Kong SAR government. And this is provided specifically in Article 60, Article 60, Article 60. Let's look at the other powers. Point 2. Power to refuse to sign bills passed by LegCo. Point 3. Power to dissolve LegCo, although the dissolution has to be preceded by consultation with the Executive Council and also what's the word for it? Suddenly escape. The need for looking for consensus, looking for consensus, right? Only after the CE has failed to reach consensus with LegCo, otherwise he can't dissolve LegCo. Fourth point is the CE's power to refuse to give written consent to bills introduced by members of LegCo. These are private members' bills, right? And that is, of course, in Article 74. Article 74. And the power to dissolve is Article 50, just 50, Article 50. Okay, let's stop here tonight, and we'll carry on with our slides, and we should be able to finish the whole set of slides come the end of next lesson. Okay. Are there questions, please? Are there questions? Okay, thank you so much. So we'll meet again Saturday. We'll meet again Saturday. 2:30 p.m. please. Yes, 2:30 p.m. Thank you so much.